Thank you, Your Honor. For the record, Your Honor, we have with me Undersecretary J.J. Justiniano and Assistant Secretary Zebedin Asis.
Good morning, Your Honors.
Yusek Justiniano, good morning, sir. Asek Asis, good morning, sir.
Morning, sir.
Thank you.
And in obedience to the subpoena as issued by the Honorable Chair and approved by the Senate President, with us today, I have 6 whistleblowers for today's proceedings, Your Honors. And these are Mr. Ben-Hur Lui, Mrs. Gertrudes Lui, Ms. Marina Sula, Ms. Merlina Sunyas, Ms. Arlene Baltazar, and Ms. Monette Briones. So these are the 6 whistleblowers willing, although with great hesitancy, to appear before this proceedings. And if I may, Your Honor, may I just briefly state a particular position in order to understand also the perspective of the Secretary of Justice, why during the last hearing she opted to first request that a matter be referred to the Honorable Ombudsman. May I state for the record, Your Honor?
Please make it short, but please proceed.
Thank you so much. We are here in order to preserve the peace, respect, and goodwill between the executive and the legislative branches of government, with the understanding that their presence can aid in the refinement and crafting of legislation. However, I also take this opportunity to respectfully emphasize that this action goes against my better judgment as the Secretary of Justice, and that I bring them here with significant reservations. Your Honors, please understand that my task is to ensure successful prosecution of these cases and to hold accountable those who have stolen the people's money. It concerns me greatly that the public testimony of these witnesses before the Senate today may put them and their families, as well as the future of these cases, at greater risk. Most of these witnesses have not yet exposed their faces to the public. In fact, about 2 or 3 of them, this is the first time that the 2 or 3 of them are showing their faces to the public, not even in the course of media interviews before. They are still afraid to do so. In terms of their personal security, my better judgment tells me that the only time that their public appearance is entirely necessary is during the trial, on the witness stand, and definitely not in front of national television. At the same time, case build-up on those yet to be filed and even those already filed with the Ombudsman is still ongoing. The NBI's case build-up is still continuing, a process that does not stop even during preliminary investigation. Having the witnesses take in further detail about what they know can reveal parts of our legal strategy, the identity of others who may be charged in the future, and other matters regarded as privileged law enforcement information. Certain information known only to the witnesses and NBI investigators is deliberately kept from public knowledge and access for valid reasons. Public knowledge of and access to this information will give some of those involved a chance to preempt our efforts, or even worse, to escape. The least that the prosecution of these cases need is a live broadcast of prosecution strategy that has been carefully developed in the course of the investigation. All of this, I humbly submit, will be threatened by the insights to be gained by lawyers of the other side from this public exercise. In a sense, this public hearing takes the form of a mode of discovery offered in a silver platter of interrogatories and depositions, even when none is legally required under the rules of criminal procedure. Discovery as a rule of procedure is limited to civil cases for good reason. In criminal cases, the Constitution only accords the accused the right to confront the witnesses during the trial itself, not before, and definitely not through pretrial depositions and written interrogatories, the new judicial affidavit rule notwithstanding. I am worried that this public deposition and interrogatories of sorts might compromise the integrity and effectiveness of the prosecution when information known only to it is telegraphed in advance to those who will be charged before the courts. The exhaustive examination of witnesses in criminal cases is reserved for the courtroom for good reasons. I'm constantly reminded of that. Finally, may I say that the same logic or reasoning the Ombudsman applied or invoked when she advised the Senate against the summoning of Janet Lim-Napoles applies and ought to apply as well to the witnesses present here today. So I'm glad to hear the announcement of the Honorable Chair earlier that he has written to the Honorable Senate President urging him to reconsider. While it is true, Your Honors, that some of the witnesses have already spoken with the media, and may I state for the record that that was not with my permission, or that was without my authority. Those conversations happened before the case had been filed with the Ombudsman, and at that point, there was very little we could do to prevent it. As the Ombudsman is now undertaking an independent evaluation of the cases already filed, as a prelude to the preliminary stage, if they're not yet at that stage, for the time being, I humbly submit it would drastically help the case if public statements from the witnesses would cease. Reservations that I respectfully bring before this body. I emphasize that the priority of my office is to hold accountable those who have committed wrongdoing, and I respectfully urge this respected body to aid us in achieving this goal. But then again, Your Honors, we are honoring the subpoena as issued by the Honorable Chair, and we just wish that our perspectives be appreciated by the honorable members of this committee. Thank you.
Mr. Chair.
Yes, thank you, Madam Chair, Madam Secretary. Senator Escudero.
Just a brief rejoinder, Mr. Chair. While I empathize and sympathize with the statement and position given by the Honorable Secretary of Justice, as lawyers, we all know, ma'am, even if you're with the DOJ, the job of the prosecutor is not to prosecute, and the job of the defense lawyer is not to acquit his client. But all of us, our job is to see to it that justice is done. It's not so much a question of tactics or strategy, but to make sure that whatever is the truth will come out, whether here or in the courtroom. With respect, Mr. Chairman, I would just like to place it on record to the position taken by the Ombudsman. While I understand her position as well, I read the law. The non-disclosure clause applies to her and her office, not to any of the participants in a case. Secondly, it applies only when there is already preliminary investigation. As I understand it, there is none as we speak. The Ombudsman is at the fact-finding stage. In fact, they have not yet required the respondents to answer, which would, in effect, instigate the beginning of the preliminary investigation stage of the Office of the Ombudsman. But having said that, Mr. Chair, I think our colleagues are well informed of the reservations of the good secretary, and we will act accordingly, ma'am, so as not to jeopardize that nevertheless. Thank you, ma'am. Thank you, Mr. Chairman.
Your Honor, thank you for those for that statement. Consistent with the reservations, my reservations, may I again request the Honorable Committee to consider the same condition or limitation as what was done in the course of the testimony of Ben Hurloy, meaning that as much as possible, there should be no naming of names of those not yet charged. Perhaps we can name those already charged, but not those not yet charged, given the fact that we have yet really to file the cases with respect to the second and the subsequent batches. Thank you, Your Honor.
Hearing suspended for a few minutes to confer with the members of the committee.
sesyon para pagbigay daan sa pag-uusap ng mga senador.
Oo nga, no? At nakita natin na nagbigay pahayag si Justice Secretary Leila de Lima na she's adopting the same reservations. Kasi nga daw ay nakapag-file na ang ibang mga witnesses dito patungkol nga doon sa plunder case. At ang iba naman daw, Kati, medyo hinihingal pa tayo dahil galing tayo doon sa loob.
Paumanhin po mga kaibigan, galing po kami sa loob ng Senate Session Hall.
At ang iba rin mga witnesses ay apprehensive nga raw sa kanilang paglabas dahil ang iba sa kanila ay hindi pa nakakapag-file ng affidavit sa Office of the Ombudsman at talagang apprehensive daw lumabas dahil nga for security reasons.
Alam mo, Attorney JJ, aside from yung 4 na nabanggit natin kanina, may 2 pang panibagong witnesses. Ito ay si Arlene Baltazar at si Monette Briones.
Ito rin daw ay mga staff din ni Janet Lim-Napoles at talagang may kinalaman at personal na knowledge tungkol nga rin doon sa pagpapatakbo ng mga korporasyon o NGO na kanilang ginawa. At nang ma-cite naman itong si Justice Secretary de Lima nga yung kanyang apprehensions na may pending nga daw na investigasyon, sumagot naman si Senator Cheese Escudero na isa rin nga dating batikang abogado, na sinasabi niya magkaiba daw ang proseso.
Hearing resumed. The request of the Secretary is duly noted. At this point, we'd like to proceed with the administrative matters muna. So we have Ben Herluy. Welcome back, sir. Gertrudis Luy. Good morning, ma'am. Marina Sula. Good morning, ma'am. Magandang umaga po. Merlina Sunya. Magandang umaga po. Meron pa bang mga pangalan na hindi ko po nabanggit?
Arlene Baltazar
Arlene Baltasar. Good morning. Good morning, ma'am.
and Monette Briones po.
Is Monette Briones around?
Si Monette. Nandiyan po. Dito na po kayo.
Okay. Good morning, ma'am. Payo ko lang, basta sabihin ang katotohanan, sapagkat kahit balibalik ta rin, basta katotohanan ang sinasabi, hindi tayo masisira. Bago kayo magsalita, kailangan muna mag-oath. So, the Director General is hereby directed. Pakitayo lang please, mga hindi pa nag-oath.
Yung mga nandito ho for the first time, pakitayo po.